Okay, let's be real. Getting a notice from the IRS is one of the most stressful things that can happen. But look, if you've received their final notice of intent to levy, it is absolutely crucial not to panic. Instead, you need to understand that you have some pretty powerful legal rights. In this explainer, we're going to break down exactly what this notice means and give you a clear, actionable path to protect your assets.
So let's not sugarcoat it. The stakes are high. This notice means the IRS is gearing up to take your property. We're talking your bank accounts, your wages, your assets. But here's the thing. The most important part of that sentence isn't the threat. It's the fact that the law gives you the power to put up a big red stop sign. Now, the notice you're holding is probably a CP90 or an LT11. Think of this as the final warning bell. You've probably gotten other letters from them before, but this one is completely different. And understanding why it's different is the key to everything that's about to happen next. Right here, this is where the power shifts dramatically over to you. See, those previous notices, like a CP504, they were basically just warnings with very limited options. But this final notice, the CP90 or LT11, this is the one that unlocks your full legal right to a formal hearing. So what this really means is this isn't just another threat. It's your official invitation to defend yourself.
Okay, so from the date printed on that notice, a 30-day clock officially starts ticking. But I don't want you to think of this as a scary deadline. I want you to see it for what it is, your window of opportunity. It's a 30-day period where you hold the power to act and completely change the outcome.
Let's look at this timeline as your game plan. Week 1, that's the green zone. This is when you review the notice and really get a handle on your rights. Weeks 2 through 4, that's the yellow zone, where you file one critical form and start preparing your case. Your goal here is simple. Take decisive action in the green and yellow zones so that you never ever enter the red zone, which kicks in on day 31. Everything, and I mean everything, hinges on this one number, 30. 30 days. You know, it's not a lot of time, which is why taking immediate, smart action is so incredibly important. This 30-day window is your last and best chance to use your legal rights before the IRS can start taking your property. So what is this incredibly powerful right that the final notice unlocks? Well, it's called a collection due process hearing. And trust me, this isn't just some boring bureaucratic procedure. It is your single most powerful legal tool to stop a levy dead in its tracks. This CDP hearing is actually guaranteed by law. Internal Revenue Code Section 6330 to be exact. It gives you the right to have your case heard by an independent appeals officer, someone who has absolutely nothing to do with the collection agent who's been after you. The best part? Just filing the request for this hearing legally forces the IRS to hit the brakes on all collection activity. It is, quite literally, a legal stop sign. You know, filing for a CDP hearing doesn't just buy you some time. It actually gives you a seat at the table. You can propose real solutions, like a payment plan or maybe even an offer in compromise to settle for less. You can argue that the levy itself isn't appropriate. And get this, if you disagree with the final decision from appeals, you can then take your case all the way to U.S. tax court. That is a massive amount of leverage. Theory is great and all, but let's see how this actually works in the real world. We're going to look at a quick case study of a freelancer we'll call Sarah, just to see how exercising these rights can turn a full-blown crisis into a totally manageable resolution.
So meet Sarah. She's a freelance consultant who got a CP90 notice for an $18,500 tax debt. The IRS was ready to levy her business bank account, which had her entire operating capital in it. But instead of freezing up, she took action. On day 12 of her 30-day window, she filed Form 12153. That single piece of paper immediately protected her bank account. Then, at her hearing, she laid out her financial situation and ended up settling the entire debt for just over half of what she owed. She saved her business.
This story shows the two paths perfectly, doesn't it? By acting, Sarah saved her business. But what if she had done nothing? Well, on day 31, the IRS would have taken every single penny from her account, effectively putting her out of business overnight. The entire outcome was decided by her choice to act inside that 30-day window. Okay, so we've covered the why you need to act. Now, let's get into the how. You stop the levy by formally requesting your collection due process hearing, and you do that with one simple but incredibly powerful form. This right here is your Legal Shield Form 1215-3, the request for collection due process hearing. It's a really straightforward one-page form. You just download it, fill out your basic info, and then mail it, and this is important, send it certified so you have proof to the address listed on your notice. The moment you do this, the law says the IRS must stop any levy action against you. It's that powerful.
So once you get your hearing, you have options. It's not a dead end. If you have a steady income, you can try for an installment agreement. If you truly can't pay the full amount, like Sarah, you might be a good candidate for an offer in compromise. And if you're in a really tough spot financially, you can ask to be placed in currently not collectible status, which basically just pauses everything. Your job is to present the option that truly reflects your financial reality.
So really, the big takeaway is this. That final notice isn't just a threat from the IRS, it's a transfer of power directly to you. They've given you the rules of the game, the 30-day timeline, and the legal right to a fair hearing. The ball is officially in your court. The next move is yours.